Hi everyone, my name is Ava, how are you? And this is Alexa, Stella and Jinky. We are the Young Roots. What is a quarry? Quarry is any common stone or other common mineral substances. In large-scale quarry operations, it involves cement raw material, marble, granite, and sand and gravel and construction aggregates that any qualified persons may apply for a mineral agreement.
Hi, Jinky here. Let us all know who may apply for a quarry permit. Any person can apply with the provincial governor or city mayor through the provincial or city mining regulatory board for the extraction, removal and disposition of quarry resources covering an area of not more than 5 hectares and a production rate of not more than 50,000 tons annually and whose project cost is not more than 10 million for a term of 5 years from the date of issuance thereof. Renewable for like period but not to exceed a total term of 25 years. Have you heard the case of Republic versus Rosemoor Mining and Development Corporation? In this case, the quarry license permit issued in the name of Rosemoor Mining Development Corporation allowed the corporation to extract and dispose of marbleized limestone from 330.3062 hectare land in San Miguel, Bulacan. The license is, however, subject to the terms and conditions of Presidential Decree 463 and the governing law was granted at that time. The license was subject to Section 69 of PD 463 stating the maximum area of quarry license. It provides a quarry license shall cover an area of not more than 100 hectares in any one province and not more than 1,000 hectares in the entire Philippines. The court stated that the law is clear and neither provides any exception nor makes any reference to the number of applications for a license. And if the law is clear, plain and free from ambiguity, it must be given its literal meaning and applied without attempted interpretation. Hence, the petition was granted.
Hello there, I am Alexa. There are 4 members of the Provincial or City Mining Regulatory Board. First is the provincial governor or city mayor or his or her representative as vice chair. Second is the small-scale mining representative. Third, the large-scale mining representative, and the last one is the department duly accredited environmental non-governmental organization representative. Take note that the concerned regional office shall provide a technical secretariat to the board. Their role is to accept, process and evaluate applications and determine administrative charges and fees for quarry.
Hi, my name is Stella. There are 3 kinds of sand and gravel permits. First is the commercial sand and gravel permit. Second is industrial sand and gravel permit. And third is the exclusive sand and gravel permit. There are also 2 kinds of gratuitous permits: the government and the private. And lastly, there are 2 kinds of guano permit: gratuitous guano permit and the commercial guano permit.
Permits. Under sand and gravel permits, we have industrial sand and gravel permit, commercial sand and gravel permit, and exclusive sand and gravel permit. The industrial sand and gravel permit. The industrial sand and gravel permit is the government permit granted for the extraction, removal and disposition of sand and gravel and other loose or unconsolidated materials that necessitate the use of mechanical processing. Issuance of sand and gravel industrial permit for 5 hectares but not exceeding 20 hectares is being issued by the Mines and Geosciences Bureau Regional Office. Industrial sand and gravel permit of not more than 5 hectares are approved by the concerned provincial governor or city mayor. Indicated on the face of the industrial sand and gravel permit are the ISAG number, the date of its issuance, name of permit holder, the address of the area upon which sand and gravel is to be extracted, and the amount of sand and gravel to be extracted. Also indicated in the permit are the following: the permit's valid period, which is 5 years, subject for renewal for the same length of time but shall not exceed 25 years, and that the permit holder must have complied with the Philippine Mining Act of 1995. The permit shall only be for the holder's exclusive use, and that the area the permit covers shall only be used for extracting and disposing of materials authorized. The permit cannot be assigned, transferred or conveyed without proper authorities' approval. Extraction is prohibited within 1 kilometer from water reservoirs, public water supply, archaeological and historical sites, or any public or private structures with a proper authorities' clearance. Extraction is not allowed within 500 meters from coast and 200 meters from mean low tide level along the beach. Permit holder shall execute a bond prior to the issuance of permit. Said bond must be maintained throughout the permit's validity until it is cancelled by the government. Quantity of materials to be extracted in compliance with this industrial permit shall be by the holder's discretion, but subject to limitations when public interest demands. Permit holder shall regularly update the MGB regional director with regard to production reports stating the quantity of materials extracted and disposed of and the amount of fees paid. This shall be submitted 10 days prior to the end of each quarter. The municipal treasurer where permit area is situated shall be copy furnished of the same. Inspection of extraction site, books of account, and other data of holder may be conducted any time as authorized by the regional director or his representatives. Extraction shall only be confined within the designated area specified in the permit. Permit area shall always be available for inspection. Holder shall pay taxes pursuant to provisions of the National Internal Revenue Code. Permit may be cancelled any time due to permit holder's non-compliance with the Philippine Mining Act or when public interest requires. Holder shall assume full responsibility and shall be liable for damages caused to any private or public property. Operation of extraction site shall be safe, non-polluting, and self-sustaining. Holder shall not discriminate on basis of gender and shall respect all rights of the workers engaged in the extraction operation. Holder shall conform to laws, rules and regulations regarding labor, safety and health, among others. Holder shall not interfere with others' rights. Holder shall recognize and respect rights, customs and traditions. Holder shall immediately stop digging the moment man-made artifacts are found. In the event of which, he shall inform the authorities of such find for its due recovery. Holder shall not acquire title over permit without prejudice to its acquisition of land or surface rights as the law provides. Holder is obligated to pay fees and taxes in accordance with law. Holder is obligated to comply with provisions of the ECC. Statements made in the application or made later in support thereof shall be considered as condition and essential to this permit. Any misrepresentation shall be cause for its cancellation. Permit holder shall bind himself to comply with RA 7942 and the revised implementing rules and regulations not inconsistent with the Constitution, and those deemed to be for national interest and public welfare. Permit shall be signed by the MGB regional director, and upon acceptance of the terms and conditions stated therein, by the permit holder, and in the presence of 2 witnesses. Said permit shall be signed and affixed with the notarial seal of a notary public. Commercial Sand and Gravel Permit. Commercial Sand and Gravel Permit is a permit granted by the provincial governor to extract and remove sand and gravel, or other loose, or unconsolidated materials, which are used in their natural state, without undergoing processing from an area of not more than 5 hectares and in such quantities as may be specified in the permit. Indicated in the face of the Commercial Sand and Gravel Permit is the commercial permit number, its application number, the date of its approval, and the name and address of the permit holder. Also indicated therein is the address of the site of extraction. The Quarry Resources Survey Plan number, technical description thereof. In the Commercial Sand and Gravel Permit, almost all of the terms and conditions mentioned at the Industrial Sand and Gravel Permit also applies. The only difference is that the Commercial Sand and Gravel Permit is valid for 1 year only. Instead of the MGB Regional Director, in the Commercial Industrial Sand and Gravel Permit, the Provincial Governor, or the City Mayor and his authorized representatives may, at any time inspect the extraction site. The Provincial Governor or City Mayor may also revoke or cancel the Commercial Sand and Gravel Permit at any time, when public interest so requires. Exclusive Sand and Gravel Permit, Government Gratuitous Permit, and Private Gratuitous Permit. An exclusive sand and gravel permit may be granted to any qualified person by the provincial governor to quarry and utilize sand and gravel or other loose or unconsolidated materials from public lands for his own use, provided that there will be no commercial disposition thereof. A government gratuitous permit may be granted to any government entity or instrumentality by the provincial governor to extract sand and gravel, quarry, or loose unconsolidated materials needed in the construction of building and infrastructure for public use, or other purposes over an area of not more than 2 hectares, for a period coterminous with said construction. Private gratuitous permit may be granted by the provincial governor to any landowner. Same the terms and conditions apply for exclusive sand and gravel gratuitous permit, government gratuitous permit, and private gratuitous permit. The permits shall be valid for 60 days or coterminous with the construction stay of the project. However, in government gratuitous permit, it shall not exceed 1 year from the date of permit's issuance. For government and private gratuitous permit, permit holder shall pay the government and excise tax pursuant to Section 151 of the National Internal Revenue Code as amended. For the government gratuitous permit, the concerned government office shall, whenever practicable, use and utilize its own vehicle and equipment in extracting, hauling and transporting the materials, provided that the permit holder may enter into a contract with a private person or entity for the purpose of hauling and transporting such materials. For the government gratuitous permit, the materials authorized to be removed shall be strictly for infrastructure project and in no case shall the same be disposed of commercially, otherwise, persons responsible thereof shall be liable for prosecution under appropriate laws. Guano permit. A guano permit may be granted by the provincial governor to any qualified person for extraction and utilization of loose, unconsolidated guano, and other organic fertilizer materials, in any portion of a municipality where he has established domicile. The permit shall be for specific caves and/or for confined sites with locations verified by the department's field officer, in accordance with existing rules and regulations. Upon the face of the guano permit, the guano permit number and application numbers, the date of its approval, the name and address of the permit holder, are indicated. The terms and conditions of permits under the Philippine Mining Act of 1995 apply with the guano permit. The only difference are the following. The term of the permit shall be for a period of 1 year from date of issuance or upon extraction of the quantity as specified in the permit. Use of explosives for extraction of guano is strictly prohibited. Guano extraction and removal shall be confined within the area specified in the permit. These areas have been subjected to survey rules and regulations. However, areas close to mining locations are excluded from the terms of this permit. And lastly, the permit shall be signed by the provincial governor and the permit holder, and affixed with the signature and seal of a notary public.
What are the grounds for cancellation, revocation and termination of a quarry, sand and gravel, gratuitous, guano and gemstone gathering permit? First, is the failure to comply with the terms and conditions of the permit. Second, if there is a violation of any provision of the Philippine Mining Act of 1995. Third, is the failure to pay the excise tax for 2 consecutive years. Fourth, is any misrepresentation in any statement made in the application or those made later in support. Fifth, if the commodity stipulated in the permit has been exhausted before the expiry date. And lastly, is when national interest and public welfare so require or for environmental protection or ecological reasons. And always remember, that upon cancellation of the permit, the said areas shall automatically be reverted back to its original status.
Going to measures to ensure mine safety and environmental protection. All contractors and permittees shall strictly comply with all the mine safety rules and regulations concerning the safe and sanitary upkeeps of mining operations and achieve waste-free and efficient mine development. All mining and quarrying operations that employ more than 50 workers shall have at least 1 licensed mining engineer with at least 5 years of experience in mining operations, and 1 registered foreman. As for mine labor, no person under 16 years of age shall be employed in any phase of mining operations and no person under 18 years of age shall be employed underground in any mine. As to who has the powers to issue orders. The mine's regional director shall, in consultation with the Environmental Management Bureau, forthwith or within such time as specified in his order, require the contractor to remedy any practice connected with mining or quarrying operations, which is not in accordance with safety and anti-pollution laws and regulations. In case of imminent danger to life or property, she may summarily suspend the mining and quarry operations until the danger is removed, or appropriate measures are taken by the contractor or permittee. As for pollution cases under the jurisdiction of the Pollution and Adjudication Board, the Pollution and Adjudication Board under RA No. 3.9.3.1, as amended by PD No. 984, has not been divested of its authority to try and hear pollution cases connected with mining operations by virtue of the subsequent enactment of the Philippine Mining Act of 1995. The Mines and Geosciences Bureau was created under EO No. 292 to abolish Bureau of Mines and Geosciences, Mineral Reservations Development Board and the Gold Mining Industry Development Board to recommend policies, regulations, and programs pertaining to mineral resources development, assist in the monitoring and evaluation of the Bureau's programs and projects, and to develop and promulgate standards and operating procedures on mineral resources development. On the other hand, the Pollution Adjudication Board was created and granted under EO No. 192 broad powers to adjudicate pollution cases in general. Section 2 paragraph A of PD No. 192 defines the term pollution. The authority of the Mines Regional Director is complementary to that of the Pollution Adjudication Board. The Mines Regional Director has exclusive jurisdiction over safety inspections of all installations, surface, or underground mining. Power to issue order requiring a contractor to remedy any practice in accordance with safety and anti-pollution laws and regulations. Regulate and monitor activities within mining operations and installations. However, while the Mines Regional Director has express administrative and regulatory powers over mining operations and installations, he has no adjudicative powers over complaints for violation of pollution control statutes and regulations. Now, moving to environmental impact assessment. Except during the exploration period of a mineral agreement or financial or technical assistance agreement or an exploration permit, an environmental clearance certificate shall be required based on an environmental impact assessment and procedures under Philippine Environmental Impact Assessment System, including Sections 26 and 27 of the Local Government Code, which requires prior consultation with the local government unit, non-governmental and people's organization and other concerned sectors of the society. People's organizations and non-governmental organizations shall be allowed and encouraged to participate in ensuring that contractor permittees shall observe all the requirements of environmental protection.
Now that we have talked about the safety and environmental protection aspect in mining and quarry operations, let's now discuss surface rights. Section 75 of Republic Act No. 7942 provides that when mining areas are so situated that for purposes of more convenient mining operations it is necessary to build, construct or install on the mining areas or lands owned, occupied or leased by other persons, such infrastructure as roads, railroads, mills, waste dump sites, tailings ponds, warehouses, staging or storage areas and port facilities, tramways, runways, airports, electric transmission, telephone or telegraph lines, dams in their normal flood and catchment areas, sites for water wells, ditches, canals, new riverbeds, pipelines, flumes, cuts, shafts, tunnels, or mills. The contractor, upon payment of just compensation, shall be entitled to enter and occupy said mining areas or lands. When it comes to entry to lands, Section 76 of Republic Act No. 7942 and Section 107 of DOW 96-40 are the governing provisions and rules. Section 76 states that for entry into private lands and concession areas subject to prior notification, holders of mining rights shall not be prevented from entry into private lands and concession areas by surface owners, occupants, or concessionaires when conducting mining operations therein, provided that any damage done to the property of the surface owner, occupant, or concessionaire as a consequence of such operations shall be properly compensated as may be provided for in the implementing rules and regulations. Provided, further, that to guarantee such compensation, the person authorized to conduct mining operations shall, prior thereto, Post a bond with the regional director based on the type of properties, the prevailing prices in and around the area where the mining operations are to be conducted, with surety or sureties satisfactory to the regional director. Meanwhile, under Section 107 of DOW 96-40, any damage done to the property of the surface owner, occupant, or concessionaire thereof as a consequence of the mining operations or as a result of the construction or installation of the infrastructure mentioned in Section 104 above shall be properly and justly compensated. Such compensation shall be based on the agreement entered into between the holder of mining rights and the surface owner, occupant or concessionaire thereof or, where appropriate, in accordance with Presidential Decree No. 512. In case of disagreement or in the absence of an agreement, the matter shall be brought before the panel of arbitrators for proper disposition. For the policy of multiple land use, the Philippine Mining Act of 1995, recognizing the equiponderance between mining and timber rights, gives a mining contractor the right to enter a timber concession and cut timber therein, provided that the surface owner or concessionaire shall be properly compensated for any damage done to the property as a consequence of mining operations. Now, let's talk a little about the historical background of Section 76. Section 76 was first found in Section 27 of Commonwealth Act No. 137, which took effect November 7, 1936. Similarly, some pertinent provision in relation to this was also incorporated in Presidential Decree No. 463, otherwise known as the Mineral Resources Development Decree of 1974. However, hampered by the difficulties and delays in securing surface rights for the entry into private lands for purposes of mining operations, Presidential Decree No. 512 was passed into law to achieve full and accelerated mineral resources development. PD 512 provided for a new system of surface rights acquisition by mining prospectors and claimants. The power of eminent domain may now be invoked by mining operators for the entry, acquisition and use of private lands. Whereas in CA No. 137 and PD No. 463, eminent domain may only be exercised in order that the mining claimants can build, construct or install facilities. The evolution of mining laws gives positive indication that mining operators who are qualified to own land are granted the authority to exercise eminent domain for the entry, acquisition and use of private lands in areas open for mining operations. Section 76 constitutes compensable taking for public use. In the case of DDPO Earth Savers Multi-Purpose Association Incorporation v. Gozan, petitioner sought to nullify Section 76 of Republic Act 7942 and Section 107 of DOW 9640, which their claim allows the unlawful and unjust taking of private property for public use, in contradiction with Section 9 Article 3 of the 1987 Constitution, mandating that private property shall not be taken except for public use and the corresponding payment for just compensation. However, the court ruled that considering Section 1 of PD 512 granted the qualified mining operators the authority to exercise eminent domain, and since this grant of authority is deemed incorporated in Section 76 and Republic Act 7942, the inescapable conclusion is that the latter provision is a taking provision. While this court declared that the assailed provision is a taking provision, this does not mean that it is unconstitutional on the ground that it allows taking private property without determination of public use and the payment of just compensation. Mining industry plays a pivotal role in the economic development of the country and is a vital tool in the government's thrust of accelerate recovery. The importance of mining industry for national development is expressed in Presidential Decree 463, which states that mineral production is a major support of the national economy and therefore the intensified discovery, exploration, development and wise utilization of the country's mineral resources are urgently needed for national development. Irrefragably, mining is an industry which is of public benefit. The determination of compensation by the panel of arbitrators is only preliminary. As to the contention that Republic Act 792 and Section 107 of DOW 9640 encroach on the power of the trail courts inasmuch as the same determination of proper compensation are cognizable only by the panel of arbitrators. The court held that although Section 105 confers upon the panel of arbitrators the authority to decide cases where surface owners, occupants, concessionaries refuse permit holders entry, thus necessitating involuntary taking, this does not mean that the determination of the just compensation by the panel of arbitrators or the Mines Adjudication Board is final and conclusive. The determination is only preliminary unless accepted by all parties concerned. There is nothing wrong with the grant of primary jurisdiction by the panel of arbitrators or the Mines Adjudication Board to determine in a preliminary matter of the reasonable compensation due to the affected landowners or occupants. The original and exclusive jurisdiction of the courts to decide determination of just compensation remains intact despite of the preliminary determination made by the administrative agency.
Under Section 77, there shall be a panel of arbitrators in the regional office of the department composed of 3 members. 2 of whom must be members of the Philippine Bar in good standing, and the other one is a licensed mining engineer or a professional in a related field and duly designated by the Secretary as recommended by the Mines and Geosciences Bureau Director. Those designated as members of the panel shall serve as such in addition to their work in the department without receiving any additional compensation. As much as practicable, the said members shall come from the different bureaus of the department in the region. The presiding officer thereof shall be selected by the drawing of lots. His tenure as presiding officer shall be on a yearly basis. The members of the panel shall perform their duties and obligations in hearing and deciding cases until their designation is withdrawn or revoked by the Secretary. Within 30 days, after the submission of the case by the parties for decision, the panel shall have exclusive and original jurisdiction to hear and decide on the following. First is the disputes involving rights to mining areas. Second is the disputes involving mineral agreements or permits. Third is the disputes involving surface owners, occupants and claimholders or concessionaries. And lastly is the disputes pending before the Bureau and the Department at the date of the effectivity of this Act. Surface rights must be based on compliance with legal requirements. Under the Regalian Doctrine, minerals found in one's land belong to the state and not to a private landowner. Nonetheless, a condition sine qua non is the prospecting, exploration, discovery and location must be done in accordance with the law. As it is, SMPI's right to use and exploit the mineral resources discovered and located never matures because of its omission to comply with a condition precedent. Its claim for surface rights and the right-of-way would be countenance illegal trespass into private property. Under Section 106, a voluntary agreement between a surface owner, occupant or concessionaire thereof permitting holders of mining rights to enter into and use its land for mining purposes shall be registered with the concerned regional office. The said agreement shall be binding upon the parties, their heirs, successors in interests and assigns.
Now, we are going to talk about the transport, sale and processing of minerals. Under Section 53 of Republic Act No. 7942, also known as the Philippine Mining Act of 1995, ore transport permit was defined. It is a permit specifying the origin and quantity of non-processed mineral ores or minerals shall be required for their transport. Transport permits shall be issued by the Mines Regional Director who has jurisdiction over the area where the ores were extracted. In the case of mineral ores or minerals being transported from the small-scale mining areas to the custom mills or processing plants, the Provincial Mining Regulatory Board concerned shall formulate their own policies to govern such transport of ores produced by small-scale miners. The absence of permit shall be considered as prima facie evidence of illegal mining and shall be sufficient cause for the government to confiscate the ores or minerals being transported, the tools and equipment utilized, and the vehicle containing the same. Ore samples not exceeding 2 metric tons to be used exclusively for assay or pilot test purposes shall be exempted from such requirement. In Mineral Trading Registration, Section 54 of the Philippine Mining Act of 1995, no person shall engage in the trading of mineral products, either locally or internationally, unless registered with the Department of Trade and Industry and accredited by the Department, with a copy of said registration submitted to the Bureau. In Minerals Processing Permit, no person shall engage in the processing of minerals without first securing a minerals processing permit from the Secretary. Minerals processing permit shall be for a period of 5 years renewable for like periods but not to exceed a total term of 25 years. In the case of mineral ores and minerals produced by the small-scale miners, the processing thereof as well as the licensing of their custom mills, or processing plants shall continue to be governed by the provisions of Republic Act No. 7076, also known as People's Small-Scale Mining Act of 1991. A foreign-owned or controlled corporation may be granted a mineral processing permit. The transport of all minerals by permit holders, contractors, accredited traders, retailers, processors and other mining rights holders must be accompanied by an ore transport permit that is issued by the regional director concerned or his or her representative. Provided that the sand and gravel shall be covered by a delivery receipt. For MPSA and FTAA contractors, ore transport permit shall be issued if there is a written notice prior to shipment or transport of ores that shall be furnished to the regional office concerned for the purpose of monitoring mining activities in the contract area and if such activity is in accordance with the terms and conditions of the agreement. An OTP is not necessary for ore samples not exceeding 2 metric tons to be used exclusively for assay and pilot test purposes. Instead, a certification shall be issued by the regional director concerned. For ore samples exceeding 2 metric tons, an OTP shall be issued by the regional director for a limited amount based on the type of ore, metallurgical tests to be undertaken and other justifiable reasons as determined by the regional office concerned. In the absence of any of the required documents, it shall be considered prima facie evidence of illegal mining and shall cause confiscation or seizure of the minerals or mineral products and the tools and equipment including conveyance used in the commission of the offence in favour of the government pursuant to PD No. 1-2-8-1, subject to further investigation. If it is found that the minerals seized have been mined, extracted, or removed without any permit or authority under existing mining laws, rules and regulations, final confiscation can be effected to be followed by the filing of the complaint for theft of minerals. The regional director and other bureau personnel, DENR personnel duly authorized by the secretary, contractor, permit holder, and other duly deputized personnel shall have the authority to arrest offenders and confiscate or seize illegally sourced minerals used in the commission of the offense. It shall be the primary responsibility of the permittee, contractor, or permit holder to police the permit or contract area from any illegal mining operations. In case of apprehension by the Bureau field officer, the mineral products and equipments used shall be deposited with the concerned regional office for safekeeping. In case of apprehension by the Philippine National Police, Economic Intelligence and Investigation Bureau, Coast Guard and other government law enforcement agencies, the apprehending agency shall notify the CONCENRED regional office and turn over the seized items for proper investigation and disposition. For confiscated gold and other precious metals, the concerned regional office shall first determine if they conform with the Central Bank of the Philippines specifications or requirements for acceptance.
And that concludes our report regarding Quarry. We are the Young Roots. Thank you for watching.